Hello. Welcome to our weekly lawyer continuing legal education seminar. I'm Heather Doothright, and this week we're covering the topic, how can we improve the speed of justice for our clients? Jamie McGilvery will be leading our discussion today. So without further ado, Jamie, I'm going to pass it on to you.
Hey, thanks, Heather. So I think I'll turn to Kyle in our Halifax office. Did you have some comments on that issue, Kyle?
Yeah, one thing I thought of was the increased reliance on alternative dispute resolution, whether it be through a private mediator or a settlement conference, especially with the use of video conference technology. It opens the door to more mediators, so we're not limited to a specific geographic area, such as Halifax. We might be able to get an expert mediator from Ontario, and increases the availability to get one scheduled in a timely manner.
And why, Kyle? Why, Kyle? Why do you think that would speed things up? For the client in terms of getting their case done and closed and getting their compensation.
So I think it can speed things up, especially with a private mediator where we seek that out, that independent expert. Otherwise, they may be stuck. An insurance company may not want to negotiate, but they are willing to talk settlement with that outside help. And it's can be a little bit quicker than relying on the court system, because the court system, we're limited with the number of judges and availability there.
How do you convince an automobile insurer to go to mediation or to ADR, alternative dispute resolution, instead of court?
So
Yeah.
I think sometimes it can be wanted because it's a reduced cost rather than the preparation for trial and organizing. If they have to get expert witnesses to be there to attend, it reduces their overall cost rather than maybe a week-long trial. They have a day-long mediation, and this way they're also able to get an outside opinion that's independent and can help value the case for them.
So how do you know? Does someone else want to talk about when a case is ready for mediation, like how we can get it ready for settlement faster and without being too fast that we're sort of prejudicing the client?
I can speak to that.
Okay.
It was just, yeah, I mean, what I always say, right? I mean, at the end of the day, what we're trying to do is work for the client and what's in the client's best interest. And I think you're right, Jamie, that it's got to be the right pace. And what I always say to the clients is, it's kind of funny phrase, but I say, we move fast, but we don't rush, because we've always got to move at that pace that's right for them. And that means building the case in the right way. You don't want to go too early. You only get one kick at the can with these things, and you've got to build the case in the right way. And I think one of the things I really love about what our firm does is that, like, we start that work as soon as the file comes in. We're already starting to build that file, and we don't do one thing at a time. It's not A, then B, then C. We're doing A, B, and C all at once. We're doing things in parallel so that the file is moving as quickly as possible, and that the things that are within our control, the way that we build that file, it starts at the beginning and it carries forward. And so by doing that and getting those things started early, we're basically setting the file up so that when it is right and it is in the client's best interest, we're ready to push for that resolution. We're ready to get it into a mediation, into settlement negotiations, whatever it is that's going to ultimately get them the result they need. We've started that process at the beginning and carried it through.
So in a car accident injury case, what kind of factors determine the time frame or how long it takes us to build the case? Like, what does that entail?
I think, yeah, it's tough, right? Because every case is different and you have to look at every client differently. Everybody's got their own story that needs to be told. And so you have to kind of look at how their progression is going. We're dealing with people that are injured, and we need to see how that injury is going to resolve, how it's going to progress. My hope for all of our clients is that the injuries resolve entirely. And if that happens, that's a good time to settle it. The unfortunate reality is that not every injury totally resolves. And then you have to kind of see if they've hit a certain plateau. So I've often found that it can take a year for that to happen. I know that there are some at other places that might say 2 years. I'm not as conservative as that. I think, again, you got to look at the case, you got to look at the facts. And what you want to do is have it ready. We do the work up front so that when we do get to that place for that client, we're in the position to move forward.
Well, there's probably different, like maybe two categories of case. One might be someone who's in an accident and has like what we call, what the medical community might call a soft tissue injury. It could be like a whiplash, or maybe there's no fracture, maybe there is a fracture, but they're not disabled from work. Then you have people who are actually disabled from work because of the injuries. So I think the time frame for when each case is ready to settle is very different. And does anyone have any thoughts about that? What might be an appropriate time frame for someone who's been injured but is not off work versus somebody who is off work? Nicole, did you want to address that issue?
Hi, yeah. It depends a lot, in my opinion, on the nature of the injury. So the more significant the injuries, the longer it's going to take to get to resolution. The more significant injuries, you really don't want to rush that process into court, because, you know, if you get to the courthouse steps and you're still in the midst of a lot of treatment and there are things happening, you're not going to have the fullness of your injuries understood. So that case might take a little bit longer.
If someone's off work, how long does it take the doctor or the experts to say, look, I don't think this person's going to ever be able to return to work? Or I think they're going to have this, because of the car accident injury, they're going to have, or whatever injury, they're going to have this diminishment in their capacity to work permanently. Like, how long do people think it takes for the medical professionals, for the experts we hire to commit that type of thing?
In my opinion, it's 18 to 24 months before a doctor is going to make a confirmation that there's maximum medical recovery. So somewhere in that stage. And once you do know those things, like this person will not return to work and a doctor has said that, then that's a point at which you already know the future, what the prognosis is, and you can move towards settlement or trial on that basis.
So it takes, like, even if someone in the worst kind of scenario where someone's totally disabled, it seems like by 2 years, maybe a little longer, you know the picture. So why does the court system take like 4 years, 5 years? And sometimes we see, you know, even worse scenarios than that. Like, why does the court system operate so slowly? Like, and the legal system as a whole, not just the courts. Like, that's, I think, the biggest problem that the public has with the system. Understandably, it takes way too long, not just for injury cases or people being denied disability, but people going through divorce, wills and estates. They're waiting to get closure on their marriage breaking up. They're waiting to get closure on their person dying. Why do they have to wait years and years? Or their injury case, they want to put it behind them. They want to move on. And that's the problem with our system. It just takes too long. I mean, one thing about us is at least our firm's interest is with the client, in that when it's resolved, we have the same interest as the client. We don't get paid until it's resolved. We get closure on the case and get compensated at the same time the client does. But to me, within that system, the defense lawyer, the court, nobody else has any motivation to try to get closure. But at least I like the fact that we do, because really, on a good day, on any day, hopefully, we should be trying to speed up the process any way we can. But I struggle with how we do that, how we can influence the defense and the court to try to help us move the cases faster. Does anyone have any thoughts on ways we can do that?
Yeah, I think getting your court dates as early as you can because they are so far out down the road. I mean, that piece is out of our hands. The court system is really backed up. And so the piece of getting your trial dates, and they're a year and a half or 2 years out, that part's out of our hands. But getting those dates at a fairly early stage is important, because then you know you've got your end date, which is a couple years down the road. And that gives you the time you need to make sure that the client is ready in terms of the understanding of their condition and prognosis, and you've got your expert opinions lined up and so forth.
If I could just add a comment to that, I think making use of the simplified procedure is a really great way to set certain cases down for trial. And by simplified procedure, I mean different jurisdictions have rules in place which basically streamline getting a case closer to trial if it's of a lower value. So in Nova Scotia, the threshold is $150,000. If you believe a case is worth less than that, you can make a claim that the case is within a special rule, and that allows you to get your trial dates as soon as pleadings close. So instead of waiting, you know, a year and a half to complete additional steps and then waiting 2 more years to get your trial dates, you can get trial dates within, you know, 2.5 years, if not less, from when your pleadings close, which adds additional pressure and encourages settlement.
And to pick up on Madison's point, at least here in New Brunswick, we've also been using more the summary judgment rule in order to move matters along, which was essentially just a quick ruling, a ruling prior to trial on whether there's a valid defense. So we're trying to use that more to speed things up.
So what does that entail?
Summary judgment would be just an application to the court on motion, mostly with affidavit evidence, with respect to asking the court to make a finding of whether there's a genuine issue requiring a trial. And the courts have held in New Brunswick that partial summary judgment is allowed. So on issues with, let's say, a defense taking in an automobile accident case, taking an unrealistic position on liability, and that's holding everything up, you can just apply and say, okay, well, let's go fight it out and see if there's a genuine issue, and that can also speed things up.
Yeah, I think it's important to note that it's not the same in every jurisdiction. In Newfoundland, like I think the rules were updated the year after I was born, and now I'm nearly 40. So it's kind of like there's some mechanisms in other provinces that we don't have here, but there are some mechanisms that we can use to keep the pressure on the defense in order to get things moving, because sometimes it's out of our hands, but sometimes it's due to slow, other lawyers being slow to act or something like that.
Well, and I think that's a great point, Andrew, and Jordan as well, because I've seen Jordan use that summary judgment to great effect, and I think it does, for the right cases, give you the right outcome. One of the things that I think is great about our firm, we've got a lot of experience across all these provinces, and everyone here knows the rules intimately and knows how to leverage those. So, there is some things that are outside of our control. I think that the judicial system is probably under-resourced. We've recently encountered things where things that were scheduled have been bumped because there's not a judge available. That's a problem. But what we can do, I think, is we can control things within the process. We can use the rules, leverage that experience that we have, that knowledge, so that we don't have to approach every case the same. We can look at each one individually and apply the rules in a way that moves things as quickly as they can be pushed to the outcome that we need.
Yeah, it's sometimes helpful too to remind maybe the judge or the defense, like rule number 1 is that in the civil procedure rules is in Nova Scotia is these rules are for the just, speedy, and inexpensive determination of every proceeding. And they can write these things in, but it's harder to put them into action. But maybe it's helpful to remind that's kind of rule number 1. These are designed to make things speedy, which is in some cases kind of ironic because they're not moving fast enough, right? But is that the same in other provinces? like Newfoundland or
So one thing that I'd like to see changed, and this is a common theme online, if you're to look up like what causes lack of justice or speediness in justice, it's this lack of robust case management. And I have the advantage of practicing on PEI, and they have a very refined system for case management. You get a call approximately every month from a court clerk who checks in. And she'll ask, you know, what stage of the proceedings are you at? And set defined timelines for completing tasks, whether it's setting discovery dates or exchanging documents or what have you. It puts an accountability on plaintiff counsel, but also defense counsel. And we see fewer delays, at least in Prince Edward Island, compared to my experience in Nova Scotia. So one change that I'd like to see is some more oversight by the courts. We shouldn't have to beg to have a case manager assigned to a file. It should be uniform across the board. Also, and this is perhaps, Jamie, a question you can answer because I don't have the advantage of time to understand how this happened in Nova Scotia, but why do we have to be looking for court dates and competing with the criminal system where there's already these Jordan precedents? So for those of you who don't know, the Supreme Court of Canada basically said it's unfair that people have to wait for an unreasonable long time for their criminal matter to be heard, but we don't have similar jurisprudence with regards to civil trials. So why is there not a separate court system for trials? Like we have a separate family court, but why is there not something similar for civil? Why are you competing with the criminal system here?
Yeah, that's a really, really interesting point. I don't know. It would require some kind of fundamental change by the legislators to put that into place. And I don't know how, like the medical system gets more attention than the legal system, I think, but is it always helpful that the judge or the court clerk is involved earlier?
Absolutely. And I'm asking my friends here, Madison, I know you practice on PEI, and Matt, I think you do a little bit of work on PEI as well. And I assume most of your experiences have been very similar to mine. I welcome those case management calls every month. And you know, I think it could be a big change here in Nova Scotia, and whether we have to get involved and, you know, lobby our local governments to see those kinds of changes, or maybe it's just with the Nova Scotia Barrister Society. I think there's a way to have better systems in place. We're you know, a strong province, and we certainly have a big membership, but we're still getting hiccups with technology. For example, our courts are really backlogged. We're still having to print out things that should be paperless. I mean, our firm is a leader when it comes to running a paperless office, but our court system doesn't match what we've achieved. There's a reason that we're one of the strongest firms in the Atlantic provinces, and it has a lot to do with our technology. And I'd like to see us all get involved, like I say, whether it's with local governments or with, you know, our governing bodies, to see if we can affect change in those areas.
Just to add to Melanie's comments, it is extremely unfortunate that the courts during the pandemic were accepting electronic documents. And we were all successful. The courts were successful. Everything was happening very, very efficiently. And as soon as the threat of the pandemic was over, we actually went back in time. And I cannot understand why that happened. You know, I think that we can improve our efficiency at least, you know, by increments. You know, being paperless and you know, delivering documents or receiving documents electronically from the court is extremely helpful. And another thing that Melanie pointed out, I have had the experience of you know, dealing with the court in PEI, where the case management is done in a very robust manner. Actually, the same thing is available in Newfoundland as well, but again, extremely unfortunate. The Newfoundland rules are so old that my experience has been that the defense lawyers are taking undue advantage of those old rules and delaying matters for no reason whatsoever. But I think we can be aggressive. At least I have, been trying to be aggressive and file applications, file motions. Like in Nova Scotia, you can file an appearance day motion, and you will see that people will respond, people will move. So we have to make
what's appearance day?
Appearance day motion is a very brief motion where you do not require to put in any brief. You do not have to add in any affidavit. You just file a quick motion, and it is essentially for procedural matters.
So what's a motion?
It's an application to the court where you notify the defense counsel, and you have to appear before the judge. And say, for example, a defense counsel is not giving you date for a discovery examination for your client or for the defense counsel, for the defendant. You can file an application and get a date quickly.
The introduction of the appearance day in Nova Scotia enables us, when the defense lawyer is dragging their feet, to fill out a very simple form, and then all of a sudden we appear before a judge within a week or two, and we say, look, this guy isn't giving us the documents we need so that we can do the discovery hearing for our client and get this thing moving. Then it puts a fire under that defense lawyer to cooperate. Otherwise, they're going to be taken before the judge in a week and maybe be forced to act and maybe be embarrassed with their lack of a response. Is there an equivalent thing in New Brunswick and Newfoundland?
Yes. Yes, there definitely is. But it is something where you would need to, make a more robust application of what the appearance day motion is. But essentially, if there's been timelines that haven't been adhered to, you can bring it before a judge.
So do you have to file like an application with all these supporting
with affidavits and everything? And it's a bit more work, but it's definitely possible, and it's something we need to do in certain situations when there's no, because some of this stuff is, and I think one of the things that's also important to note, sometimes it's not always the defense lawyer. Like there's been times when we've been trying to get documents from third parties and that kind of thing that require these kinds of applications, like a treatment provider that hasn't gotten to our request for months and months, that kind of thing. But there are always options.
But the disadvantage to the appearance day is that it's a reactive measure. Something bad has to happen before we beg the court to get involved. Where these systems, and that's what I mean by a robust case management system that's put in place on every single case so that everyone, the good ones and the bad ones, are subject to the same rules. It causes delay to have to do these appearance days. And a lot of times, if you have to ask for a case management judge to be assigned, it's looked at as an exceptional request, not something that should be standard.
It's a good point, Melanie, and I think there's a few things that the court can look at. We've really touched on those, but Ali's comments of earlier that the court seems to be moving backwards in time is really reflected in conversations that I'm having with Defence Counsel and other plaintiff counsel. It seems like something that we kind of should have used the momentum from COVID and kept going with that. And I understand in the States that they are doing a lot in that regard. They are trying to speed that up as well. So it is a shame that we move backwards. But I think there's some things that the courts can do and some things that we as plaintiff counsel can do. I think a lot of them we are already doing, and a lot of them that clients can do. In terms of doctor familiarity with clients and they often their willingness to support clients. I think it's important that the clients do see the doctors often enough, are familiar enough with their conditions, that the doctors know, in a disability situation, what the person's job is, and they have enough information about that person. Of course, part of that job, I think, is ours to communicate with the doctors as well. But certainly the clients have a unique control over their own medical situation, as much as the system these days allow them. We do have of course a very robust system within the firm of dealing with potential smaller claims earlier and resolving those, and that's taken a huge load of motor vehicle accident claims off our docket, and of those that proceed, I mean, people have touched on this, but early document request and following through on regular updates, that's always key in the timeline as well, because we've seen the massive delays flowing from some requests, up to 6 months for certain records, hospitals and Revenue Canada to materialize these days. And I
can we advocate for our clients, like, and say to whether it's a case management judge, a defense lawyer, a judge assigning trial dates, at what point and how effective is it for us to say, look, this person has been off work and without income because of the accident for 3 years now, and we still don't have a trial date? Is that appropriate? Is it appropriate to sort of bring those points up to the judge?
I think in my mind, it's always appropriate. It's about the client. The only reason for any of us discussing any of the client's issues is because of the difficulty that the client is going through and then the situation they've been put in. If it isn't of concern to the courts, it certainly should be. And I think it ought to be really relevant in any sort of procedural or substantive issue that one deals with the courts. Is this serving the client and ultimately the public properly? So I do think it's appropriate. Whether the courts always are moved by those concerns is another question, but I think it ought to be, and it is for us a vitally so important factor.
Has anyone, like for me, the case management person, the ability of that to speed up the case depends on the effectiveness of that manager. And has anyone had experiences under case management where it's maybe slowed things down or just created like another layer of bureaucracy that actually backfired on the client and slowed things down? Or do we universally find that a case management judge is always helpful for the case?
The PEI case management, it's not run by a judge, Jamie. It's run by like a court clerk. So I don't know, maybe having a judge involved would be more cumbersome, but the ones with the court clerk and PEI, they're like 5-10 minute calls, if that, at 8:30 in the morning. You don't have to really do any prep work. And it's more like, hey guys, what's the next step? What's the plan? Like it's just like incentivizes counsel to just move the case forward. And if there is delay, like the court clerk, she asks, like, what's the holdup here? And counsel has to explain that. And if there's no really good reason for it, it really pushes things forward. So I've never found a situation where they've been unhelpful, and they've never been more than a few minutes. It's not like this cumbersome several hour long process. I don't really see any downside to the ones they do in PEI, at least.
In Nova Scotia, sorry, Jamie, I was just going to say, in Nova Scotia is a slightly different system. Of course, most people use case management in cases where there are multiple parties involved, and where just the scheduling and procedure to sort of get it moving forward with everyone's schedules and that type of thing is often a difficulty, and especially if there's obviously issues that are that various councils are being sort of trying to deal with, or motions being made and multiple parties asking, arguing different things. In those cases, I certainly find in Nova Scotia that they're absolutely worth it. It sort of keeps people to specific dates and specific tasks are agreed to in each step on a fairly regular basis. You can use them to almost as a motion to argue for whatever is necessary in your case. So I use them for that purpose to sort of try and obtain some edge for the client in every case management meeting in Nova Scotia, of course, where they are with the judge. So in that case it does delay it, but there is a bit of a turning point, I think, where if it's a relatively simple procedure of single defendant or maybe two defendants, it may not be worth it, because each time you are rescheduling dates for the next meeting, and it can be a bit cumbersome. But I certainly think for the bigger claims, for the ones involving multiple parties and complex issues, it's absolutely vital.
Yeah, perhaps like we can't really say to the government or the courts, you know, we need these people like in PEI. I mean, we could suggest that to someone somewhere, but it'll probably fall on deaf ears. But we can become the case manager in a way, as the lawyer and advocate for the plaintiff. We can be the ones saying, why aren't you getting back to me? You know, what can we do next?
There's definitely an element of the squeaky wheel gets the grease when it comes to communicating with other lawyers. Most will respond after, if there's no response after the first one, maybe the second or the third one. That's kind of like on a schedule almost. And
yeah, we're at the mercy of those defense lawyers, but we're not, because if they don't respond, we have a hammer in the application.
Well, this is it. I mean, you can bring that in an affidavit to a judge then, that, look, I tried to contact this person then, and they haven't gotten back to me.
I think too, right, like one of the things about, we all work in Atlantic Canada, and relative to places like Ontario, it's a smaller bar. We deal with the same counsel all the time, and they deal with us all the time. And so I think a lot of it comes down to the communications with them, where if you set expectations through your conduct, you can have good effect. If they know that if they don't do what they're required to do, you will bring an application, you oftentimes don't have to, because they know it's coming. It's one of those cases where being predictable is a good thing, because if you're predictable in the way that you're going to handle a claim, you're predictable in the way that, look, if you haven't done this in the time frames and you haven't responded to my requests, you know there's an application coming. Oftentimes that application is no longer necessary, but you've got to drive that reputation from the outset, and it doesn't have to be, you don't have to be a bully, and you don't have to necessarily be negative, but you just have to act in a way where, if you're constantly guided by the principle that your client's interests are what are important, and you're constantly advocating for them, they're going to understand, and they're going to know that they need to respond in a timely way. Because of that, we're not at their mercy. We're not at their mercy. We have options, and we can leverage them.
Yeah, like you could say, I'm not trying to be a jerk, or I don't want to drag you before the judge to embarrass you in this, but our client has no income. We have to advance this case for them. They want closure. They've been injured, and they want closure in this situation. They need the compensation. They have a family. They have their own situation. You know, we have to get this done for them, and we need your cooperation to do that. And without it, we have to bring it to the judge to help keep things up.
I think I was just going to say, I think the analogy of setting a fire is a good one, because, you know, some people, lawyers, doesn't matter, adjusters, people will react to a fire more than they will react to, you know, just to kind of like a gentle poke every once in a while.
Yeah, you don't want to be the type of lawyer that the insurance companies know if they ignore them, it'll just kind of go away for a long time, because delay always benefits the insurers, I find, because people get desperate when it drags on for so long, and they take less. And you know, some people, a certain percentage of people would die before their claim is done, the longer it takes. For an insurer, if there's thousands of cases, the longer they go, there's more. It's sad too, like their case dies with them, right? Often, and the insurer benefits that way, because that claim is gone if the person dies. So statistically, over hundreds and hundreds of cases, delay would benefit them. So yeah, I think people become desperate from delay. They take less. Some people die. Some people become frustrated and just say, I don't care what it is, I just want this over with. So it's our job to prevent delay, for sure, and to advocate at every step of the way to keep the thing moving for the client. What about in New Brunswick? Like Emma or Angus, or what kind of methodology are there?
The main difference that hasn't come up is we can get advances for loss of income. And that really helps in that situation where a client's suffering and has no income. We can get them some money so they can continue the fight. And it puts pressure on the insurer to say, if we're paying out on this anyway, why don't we try to settle it? So it can often foster settlement discussions. But one of the big things I've noticed from changing jurisdictions from Nova Scotia to New Brunswick is in Nova Scotia was quite common. I'd ask for discovery dates. Defense counsel will give me dates 8 to 12 months later. And here it's usually 3 to 4 months, sometimes even 2 months. And I think that does speed things up significantly in terms of getting discovery done and then moving on to getting the further like final pieces of evidence from there.
Has anyone ever had like a meeting with the judge and the defense lawyer where you're trying to set a date and the defense lawyer is giving dates? Every date the judge proposes, they say, oh, I'm busy then, I'm busy then. And it ends up being like Angus suggested, like 8, 12, 14 months out for even a motion or a small application or a discovery date. And if you have had that situation, how do you deal with it?
I always say that, usually they're a large firm with 100 lawyers. Like tell them to have somebody else put on the file. It's an institutional client. It's an insurance company. They're not bound to just one lawyer. And I found some judges receptive to that, some not so much.
Yeah, exactly what Angus said. I wish it. I mean, certainly some judges would never take that as an answer, and especially things. I mean, some things like trial dates. The court is booking, triple booking at the moment, or even more in Halifax. So they're not accepting the excuse of, oh, my lady, my lord, I'm double booking. They say, okay, fine, double book it then, but or make one of the other sort of people at your firm available, which I think is entirely fair, sort of to expect, in massive defense firms with multiple people, in any case, often working on the file.
Daniel, like, how have you at these case meetings with the judge and the defense lawyers to set dates, or just dealing with defense lawyer alone? How do you try, or do you try to push? How do you try to push for quicker dates?
For a quicker trial date?
Quicker trial date, or if a defendant's saying, oh, I'll do the discovery in 12 months, I'm not available, I have no time, I'm really busy, and they're setting dates like a year out for simple procedures. How can you remedy that without, you have to be reasonable to the lawyer, fair to them, but you also have to advocate for your client. So how do you balance that?
Yeah, it's well, yeah, exactly. It's a little bit of a balancing act where sometimes it can help to have or develop good relationships with defense lawyers if you have a little bit of give and take and a little bit of flexibility. Ones that are decent will be more cooperative. Like for the most part, I haven't had too many instances where a defense lawyer is booking 8 to 12 months out, usually able to get discovery dates within 3 or 4 months. If there was a lack of response, of course, we talked about the appearance day motion, which I've had to threaten before, and it usually does get a favorable response. And then if necessary, if they're not providing their client for defense and they're not willing to admit fault, we'd subpoena the defendant. With respect to getting quicker trial dates, first and foremost, really trying on our end, trying to narrow the issues and exactly what evidence we need so that we're not projecting too many days, because the more days that we're thinking it will take, the longer it'll likely take to get a date. And
how can you narrow the issue?
Well, just knowing the case really well, just knowing, okay, what evidence realistically are we going to bring to a trial, rather than taking like a shotgun approach and saying, every single expert potential medical specialty is going to be needed. So having a real strong knowledge of the case, I believe, helps you focus what type of evidence you need and helps reduce the length of trial that you're going to ask for, which will help get quicker dates. And then it's like what you insist, Jamie, and one thing that's so good about the firm is that we're already preparing to request a date to schedule trial dates, a date assignment conference before discovery even happens. And when we're at discovery, we're thinking about what type of evidence we're going to need for trial. And we're applying for the date to schedule dates as soon as we can following discovery. All these things help us get trial dates faster.
Do any of the non-lawyers management people on this call or paralegal have any perception about whether the justice system is slow or too fast? I mean, not too fast, definitely not, but whether it's what is your perception about access to justice? Maybe Alexis, that you would get from sources outside of working here and hearing us talk about it?
I just think there's a lot of a big lack of knowledge and lack of understanding. I don't think anyone in my personal life, if they were injured in a car accident, that they would have any idea what to do. I think the perception is that it takes a very, very long time and it's just a long, scary process. So I think we try to put out a lot of information to the public. So listening in this chat, there's so much information that I just think people that are actually injured or in need should be able to more easily access. So we'll try to do that as best as we can through our marketing efforts.
Yeah, I think that that's one problem. You could always answer, well, it's a long process. It's a long process. But I think we have to explain to the client and to the defense and the judge, this is what we have to do next to get this thing done, and make targets and not just say, oh, it takes a long time and kind of sit on it, right? Which we don't do. We want to get it done and we do our best. But the single biggest problem is delay in the legal system. I mean, that's the decisions, the process of the trial. It's very in-depth and effective at getting to the truth, I believe. And even the process of discoveries and all that is very effective. Everybody's well trained, but it takes way too long. That's the single biggest problem. The single biggest complaint of the public, and it's a valid complaint. And the answer isn't, this is a long process. The answer is, this is what we're going to do next. We're going to get this done for you. We're going to do everything possible. We're going to let the individuals in the system that are touching this understand why it's important to you to get this done. And that's our job to the public. We're offering justice. Well, without timely resolution, there is no justice. So the system isn't working. And we have to make it work by constantly reminding everybody involved about the importance of getting closure for people and not being afraid to speak up about that. And like people have said, not wanting to be the whiner or the negative person. Speak up on that point with love and integrity and cordiality, friendliness, but speak up and tell them about what's going on in this client's life and why they need it to get this thing done, why they need closure, without being negative, but bringing home the reality of the situation with integrity, without exaggeration, but communicate the problem. That's what being an advocate is, right? So that's what we do. Does anyone else have anything?
I just want to say, I like what you're saying makes a lot of sense. Advocating for our clients is not inconsistent with approaching things with integrity and honesty. It's in fact entirely consistent with that, right? And that's really what our job is as advocates.
Yeah, and they like you said, Steve, they have to know the hammer's there. If we will go to war if we have to, we will go into battle even on this little issue because you're just taking too long. And we're fed up with you doing this. We've seen it from you again and again. We're bringing you to appearance day. We're going to bring you to the judge for a motion. Next time they know. I have when Steve writes to me, when Stephanie writes to me in New Brunswick, I have to pay attention or I'm going to be held accountable. These aren't the kind of guys who are just wishy-washy and soft and want to be so nice and friendly all the time that I don't have to worry when they write to me. I can just ignore their letters. I can ignore their calls. They have to know there's a hammer behind it, unfortunately, because it doesn't always work on good faith, and sometimes they just need that reminder. Anyone else?
Another important point is, even during the litigation process, I think the insurance companies, they, like Alexa said, there's a lot of information out there that people would not know. For example, when a client is in an accident, they have access to Section B benefits during the whole litigation process, and I think that's a part of giving them access or speedy access to justice, because mainly most clients, they want to be able to attend treatment, and they want to be compensated. And in the interim of their legal action, there are these benefits available to them that they don't always know about, even though there might be letters sent, but it's not explained enough for them to understand. So I think one of the things that we have to do as well is make sure that clients understand during this litigation process that there is access to some benefits in the interim, such as their medical benefits and their weekly indemnity. And I think giving them the information that they need to have that process move a bit smoother for them is also important. Sometimes I know for in our situation, we don't always want to deal with the medical benefits part of it, because it does take a lot of time away from dealing with their legal action. But I think it's important, once we have that first connection with the client, to make sure that they understand what the interim benefits that are available to them.
Yeah, totally. They need to know they can get the treatment. And if their insurer isn't cooperating and giving them treatment, that we will be there to back them up and help them. For sure. And even though, like you said, weekly indemnity, that lost wages payment, it's very modest. It's not that much money, but it's something. And, there's tools available like Canada Pension Plan, disability. There's other options. There's not a lot, but there are some things. And we should be, like Thea does and says, we should be putting these options to our clients, because they don't know. We see it every day, but the client doesn't know that they haven't been injured. It's a new territory, and it's sad and hard. They're off work, they're disabled, they have limited income, and it's a trauma, and they need all the help they can get. So. Anyway, thanks to everybody for participating. Do you have anything, Heather, to close with, or?
Yeah, I just wanted to say thanks for attending the session today. I think we had some great discussion, and there's a lot of really good takeaways for everyone. So thanks again for joining, and have a great day.
Thanks, guys. Have a great weekend.
Thanks.